Hello, everyone. This is Jeff Neely. I'm with Husch Blackwell's Technology, Manufacturing, and Transportation team, and in our International Trade Regulation and Supply Chain group. I have experience in representing private parties in international trade remedies disputes in foreign jurisdictions, and I'll be doing some of the talking today along with two of my colleagues. We're excited to give today's presentation on the President's National Trade Policy Agenda for 2017. We're going to be focusing on really one subpart of that agenda, and that's the import side. The topic by itself is quite large, and even in the time that we've devoted to this today, we're not going to be able to probably do it complete justice, but at least we'll make a start on it. Obviously, there's other provisions and other parts of that trade agenda, including export issues that are very important, things like Cuba sanctions. But yeah, in the time that we have today, we're not going to be able to address those. Before we begin, I'd like to cover a couple of housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program. I'd like to take a minute to highlight a few of those. And if you have any questions during the webcast, please submit your question via the question box. We will try to answer all of the questions during the webcast today at the end of our presentation. But if a fuller answer is needed, or if we run out of time, we will definitely answer it later via email. We really appreciate audience participation and encourage you to submit any questions that you might have. There's also an icon to assist you with your viewing preferences. Accordingly, please note that you can expand your slide area by clicking on the maximize icon on the right side of the slide area, or by dragging the bottom right corner of the slide area. If you have any technical difficulties during this broadcast, please click on the help icon. It has a question mark, and it'll provide you with information regarding common technical issues. A copy of today's slide deck and additional materials are available in the resource list icon that looks like a folder at the bottom of your screen. The program has been approved for Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, Tennessee, Texas, and Wisconsin for the continuing legal education credit. To report your hours for Illinois, Kansas, Nebraska, Tennessee, or Texas, click on the CLE icon at the bottom of your screen and complete the questions. You'll need your bar numbers to submit that. And please make sure to do that before the webcast concludes. Finally, a recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with a certificate of attendance. So let's move on to who the other speakers are today, along with myself. I'm joined today by Bob Stang and by Michael Holton. Bob focuses his practice on customs and international trade law. He brings 30 years of experience to a wide range of issues that affect inbound and outbound goods, including tariff classification, valuation, country of origin markings, free trade agreements, and special trade programs. Michael focuses mostly on international trade relief and regulations, including anti-dumping and countervailing duties, escape clause issues, and similar issues, including anti-circumvention issues, which are becoming a very important part of our practice, probably the fastest growing part of the practice. I also do a lot on the international trade remedies issues and in anti-circumvention. I started my career at the U.S. International Trade Commission. I've been practicing there in other parts of the government for many years. Michael started his career at the Commerce Department. So both of us have some government experience as well as experience in private practice now. before I begin my part of the presentation, which will be the first part, which is on trade remedies, I'd like to say a couple things just sort of as an overview. This is a really interesting time for people in trade on the import side. Interesting may be a mild word. It's a wild time. It's a time that frankly nobody's seen in my lifetime, and it's a time that you probably have to go back, even before the Great Depression to see. What we have now is, of course, Donald Trump is president and has his own trade agenda, and ran on a platform that can be called protectionist without any doubt, and I think he'd be probably proud to say that. At the same time, you have the Democratic Party, which has really been the more protectionist of the parties in recent years, and particularly the labor unions, coming along with very much the same approach to many of the trade issues. So while you've got a lot of disagreement in Washington, we've got a huge amount of disagreement, obviously, on health care, on taxes, on lots of stuff. You don't, in some ways, have that much disagreement on trade. In some ways, everybody agrees, at least on the general principle, that protectionism is bad, is good, and free trade is pretty much bad. That's a pretty radical departure from things of the past, particularly for the Republican Party, but also for a big element of the Democratic Party. So with that in mind, we're going to cover the import issues today, but I think we all need to keep that in the background, is that this is really a new world that nobody has navigated before. So I'll start with my own issues here, which have to do with trade remedies. And I'd like to sort of start with an overview of that and the various kinds of trade remedies cases that are out there, and what's new and what's old and what's likely to happen. The sort of traditional trade remedies cases came in the form of anti-dumping and countervailing duty cases. Anti-dumping cases mean unfairly low pricing. Countervailing duty cases have to do with subsidies by foreign governments. Both of those types of cases are very common. They've been around for a long time, have been active under really every administration. But what we've seen now is an uptick in really in the last couple of months on the part of companies filing more of these cases. We think that trend will probably continue. There is a receptivity, let's say, on the part of the Trump administration to these cases. I think if you're a domestic industry that believes that it's being injured unfairly by dumped or subsidized imports, there has not been a better time to file a case than now. This really is an opportunity that you probably won't see again for a long time. It is highly unusual, so we've seen more of those. We'll continue to see more of them. The remedies that are applied for these unfair trade practices are in the form of additional duties. And in the case of China in particular, those additional duties can be very high. So it's a very significant way to go after imports if you're a company that feels that they're injured by them. China, as many of you know, has been the main target of such cases in recent years. Anything from furniture to steel to garment hangers to all sorts of other stuff have been brought against China. But there's been a number of other countries as well that have been caught up in this: Vietnam, Korea, even the United Arab Emirates. And we will see, I think, more countries as well as more cases in the future. One thing that has changed on the dumping and countervailing duties is the possibility of self-initiation by the government. Traditionally, the way that these cases have worked is that they're filed by private parties, perhaps a coalition of furniture manufacturers or steel companies will file a case, and then it's processed by the government over the period of more or less a year. What we are hearing is that the government is seriously considering self-initiating its own cases, which would save, to some extent, a lot of time and money, I suppose, for the private parties who want the cases. On the other hand, in an atmosphere where we're really cutting back on government employees, I'm not sure where they're going to find the resources to do this, but that is being talked about, and we really do need to put that on the table as a possibility, because that could lead to certainly more cases. Finally, one thing that we should talk about for countervailing duties in particular is the issue of currency manipulation. We heard a lot about currency manipulation during the campaign, particularly from President Trump, who said that the Chinese were manipulating their currencies. More recently, he's obviously been talking about Germany manipulating the euro as well. But at least in the case of China, after saying that he was going to take immediate action on currency manipulation once he became president, after he met with President Xi, he backed off on that and found that, in fact, China is not manipulating its currency at the moment, at least in a way that's adverse to the United States. So I suppose that could come back, but for now, that seems to be off the table. Not entirely surprising to many of us in the trade area, but it's one less thing, I suppose, that you have to worry about on the subsidy side of the cases. So let me now turn to other types of statutes and that affect trade. One part is Section 232 of the Trade Expansion Act in 1962, which obviously goes back to the Kennedy administration. It's an old act, but it hasn't been used all that often. And it really involves national security. I mean, that's the key to this particular statutory provision, is that somehow the national security of the United States is being adversely affected by imports. I'll talk about that in more detail in a second. I don't want to spend a lot of time on it right now, but it has been used within the last couple of months on steel and on aluminum, which are huge parts of the U.S. economy. And while it's been used in the past on occasions, I don't know of any use of it that has been as sweeping as this administration has done so far. Secondly, another type of case are Section 301 actions. These really are based on unfair practices of various kinds. It could be a wide variety of cases. They're undertaken by the U.S. Trade Representative's office. They can be done upon petition by private parties or self-initiated by the government. Mr. Lighthizer, who is the U.S. Trade Representative's office, is very familiar with these cases. To date, nothing's happened on that particular statutory provision. So far, they've wanted to use Section 232, but in the future, we could also see some action, I think, on Section 301 cases. Next, another provision that people need to be aware of is Section 337 of the Trade Act of 1974. It's a very broad statute. It's undertaken by the U.S. International Trade Commission. It's more like a U.S. District Court trial. It goes before an administrative law judge, and then the ITC Commission as a whole sort of confirms or overturns what the administrative law judge has done. Usually it's been used for intellectual property cases, that is, for things like patents, trademarks, to some extent copyrights. But it's very broadly written and could be used in a broader way. Right now, pending before the U.S. International Trade Commission is a case brought by U.S. Steel that seeks to broaden the use of this statutory provision to lots and lots of unfair acts of antitrust sort of allegations, conspiracy allegations, circumvention allegations. And so we're going to have to see how that all comes out at the ITC. It's pending. It was filed well before the more active things that the Trump administration has been doing, so it really didn't have anything to do with that. It had more to do with U.S. Steel's own desire to use this part of the statute, but that's going to take place perhaps more and more depending on what happens on that case. The other thing I should mention on Section 337 is that there was a recent Supreme Court case that limited venue for filing patent cases. Now, that's a really kind of obscure thing for lawyers on where venue lies, and in other words, where you can bring a case, which district court you can bring a case in. But what was happening was a lot of these cases were being brought in places like the Eastern District of Texas, which was sort of a rocket docket. It was a place where cases went very fast, and not only did they go fast, but juries there seemed to like patent holders, so people like to file cases there. The Supreme Court now says you can't do that anymore, and that obviously limits what the business that the Eastern District of Texas is going to get, but it also probably encourages people to bring more Section 337 cases, at least in the instances where the U.S. the U.S. companies see imports as being the problem. Another thing is Section 421 actions, which are just against China, have nothing to do with unfair trade practices. They have been rare, but we could see more of those in the future. And then finally, Section 201 cases against all countries. That is also a provision of law that has been very, very rarely used recently. It was used, and I'll talk about it more in a second, last time, I think it was in 2001 against steel. So it's rare, but now we've seen two of those cases in the last couple of months, one on solar panels and another one on washing machines. So let's talk about Section 232 cases for a second, because in many ways these are the most interesting new development and ones that could have a widespread impact on the U.S. economy. Two cases have already been brought, as I mentioned, steel and aluminum. The idea behind Section 232 cases is not that there are unfair trade practices, but rather that there are national security concerns being brought on because of the imports. Of course, the problem with national security concerns is that a lot of the information is secret. That means it makes it incredibly difficult for companies who would want to oppose these actions to fight back in a very meaningful way, because it can always be overcome, or I should say trumped, or whatever the word is you want to use, by the fact that in reality, this is a national security thing, but we can't tell you why. So that makes these cases particularly interesting and in some ways dangerous for companies who are importing. In neither of the cases, in neither of the steel or the aluminum case, has the scope of the case been exactly defined. The cases just say steel and aluminum. Of course, that's a really broad range of products, and how far back in the stream it goes and how far forward is really been left unclear, at least to date. Which again, if you're trying to make your points to the government about why something should or shouldn't happen, makes it dicey, because you don't exactly know what we're talking about in terms of coverage. From the May 24th hearing that the Commerce Department had on steel, however, we know a little bit more than we did before. One is that Wilbur Ross, the Secretary of Commerce, who attended the entire hearing himself, which is in itself pretty unusual, but it shows how important this is to the Commerce Department and to the administration. Secretary Ross said that upstream products for steel, things such as iron ore and other imports, likely are going to be covered. And there'll be import restrictions on those, as well as on what you might think of as basic steel products, cold rolled, hot rolled, pipes, things of that sort. And also, there were indications that further processed steel products also are going to be covered. One of the most interesting parts of the testimony, I thought, was the testimony of the CEO of AK Steel. And he mentioned that, very correctly and very honestly, that some U.S. customers, some U.S. producers would be rendered potentially uncompetitive by import restrictions on certain steel products. And therefore, his solution was that the Trump administration also needed to control imports of those downstream products. It was an interesting piece of testimony. A lot of people didn't pick up on it very much, but to me, it's one of the more interesting and possibly far-reaching parts of the testimony. So really the question becomes, how far down does the protection end for downstream products? And we don't really know the answer to that yet. The administration has announced that it intends to figure out the scope, intends to determine different remedies by the end of June, so in just a few weeks. This will include the correct level of protection in their view for potentially hundreds of products. It was able to decide whether Canada and Mexico are excluded, whether other countries are excluded, whether there will be a government agency in charge of granting specific exclusions going forward. It's a lot of work, and they have very little time to do it. And of course, in the midst of this, they also will be holding a hearing on the aluminum Section 232 on June 22nd, which will have similar issues. Are there other possible cases under Section 232? Well, we've heard rumors that they were considering cases on things like semiconductors and other products. I'm not so sure. Haven't really seen any hard evidence that that's going to happen. I think that much may depend on the reaction of the markets and the reaction of the business community as to the steel and aluminum efforts. There's no doubt that this is really potentially a radical departure regarding industrial policy, but as with lots of things, the proof is really in the details. What should the huge number of companies affected by these current cases do? A couple of things come to mind. First, if the cases are an imminent threat to you, make your views known to the Trump administration, to Congress, to your state officials. It's important, and you don't have a lot of time to do that. If relief goes into effect, and I think there will be some form of relief. I'm not a person that has a crystal ball who can tell you exactly what that's going to be, but some form of relief is pretty likely. If that happens, companies really should work to gain exemptions or to identify loopholes in that relief. So let's move on to Section 201 cases, another really broadly based form of relief. Again, as I said, it's very rare. The last one of these cases was in 2001 on steel. I worked on that case for the Mexican industry. Because of some specific Nafta provisions, we were able to get the Mexican industry out, and so we had some happy clients, but not everybody got out. Eventually it went to the WTO. It was a pretty convoluted case with lots and lots of products. So now we have sort of a resurgence of Section 201. The cases are attractive, I think, to U.S. companies and to the administration because there's a recommendation to the president by the International Trade Commission as to whether there's injury. And then there's very wide discretion on the part of the president as to how he can act, whether it's going to be in the form of tariffs, quotas, tariff rate quotas. Usually those last for about 4 years. And all it really needs to be shown is that there's a surge in imports that injure the U.S. industry and not, again, any kind of unfair trade practices. The new case that's been initiated was solar panels. It was brought by a U.S. industry that has roughly 2,000 employees. And from the figures that I've seen, at least, it may adversely affect an industry that has close to 260,000 employees. In the solar panels case, the relief requested would double the price of the cells and also would have the government impose minimum price levels. This is the relief that's requested by the U.S. industry. The key takeaway, I think, for companies that are not in the solar panel industry is that these cases could be used in other industries, and so they really need to be aware of the cases and see what happens. The issue of relief, I think, will be key. How far is the government going to be willing to go in imposing things like minimum prices? How much is it going to take into account the interest of the many, many workers who are going to be adversely affected in the U.S. industry that are consuming the foreign solar panels? So just to wrap up my part of this, I would just say that it seems likely that the entire economy in the next few months is going to feel, or could feel, depending on what happens, the effects of these broad actions. The actions are being done on an expedited basis, so actions by companies, if they are interested in participating, should be sooner rather than later, because the train is very much leaving the station. It's also possible, and we cannot rule this out, that the proposed protectionism will be like the currency manipulation issue. It'll simply be dropped and never heard from again, or at least not heard from for a while. But the uncertainty, meanwhile, and the downside, if relief goes forward, should lead companies to examine these cases very carefully and prepare for the worst. Thank you very much. That's my part, and now I'm going to turn it over to Bob Stang, who's going to cover free trade agreements.
Thank you, Jeff. I'm Bob Stang. I'm a partner with Husch Blackwell's International Trade and Supply Chain practice here in Washington. And for U.S. free trade agreements, we're going to start with a quote from one of my favorite characters, Miracle Max, played by Billy Crystal in The Princess Bride, who said, "Look who knows so much. It just so happens that your friend here is only mostly dead. And there's a big difference between mostly dead and all dead. Mostly dead is slightly alive." And that brings us to U.S. free trade agreements, both real, meaning those that are in effect, and imagined, meaning those that were under negotiation or discussion. And we have a continuum showing the mostly dead to the mostly alive. Now, before we start talking about the individual free trade agreements, we want to talk about who's actually making the decisions here. And Jeff mentioned there's really three centers of power here, and Jeff mentioned two of them. The first one being the United States Trade Representative, Robert Lighthizer, very highly respected attorney with decades of experience in the public and private sector, primarily representing the U.S. Domestic industry. And USTR is responsible, among other things, for overseeing trade negotiations. The second center of power, that's the Department of Commerce, led by Wilbur Ross. Mr. Ross is a self-made billionaire, which makes him a Trump peer, somebody who can talk to the president on that level. And he's supported by Ken Hyatt, the acting Undersecretary for International Trade, who's been with Commerce since 2010, also has an extensive amount of experience, actual experience in international trade, administering U.S. laws, in particular dumping and countervailing duties. The third center of power, which is really the most interesting one and the new one, is the National Trade Council of the United States. This was created by President Trump. It's directed by Peter Navarro, who is a very controversial economist. His background is almost exclusively in academia, very little private sector experience. And looking at the website for this, for the National Trade Council, it says that they are to advise the president in trade negotiations, which is interesting because that is also what USTR does. So when we think that you're looking at where to go, if there's a question or how to approach these issues, whether it's free trade agreements or trade remedies or whatever, consider these three centers of power and consider who's leading them and consider what's their relationship to the president, what's their relationship to the Trump campaign, and what's their background. Is it in private experience? Is it government? Is it academia? And what's their actual experience with international trade? So now moving on to actual free trade agreements. The first one, the The TTIP, the Transatlantic Trade and Investment Partnership, basically that one was a multilateral trade agreement being negotiated between the United States and the European Union. In our opinion, that one is dead. And it's not just because of the United States. This was a sweeping free trade agreement, and it was controversial, not just in the United States, but also with a number of the European interest groups. Next, we have the Trans-Pacific Partnership, maybe the most high profile of the free trade agreements that never came to be. The TPP was actually signed by all 12 countries in 2015, but as folks know, it never passed Congress and it never became law. And in our opinion, the TPP qualifies as mostly dead, which according to Miracle Max means slightly alive. January 23rd, Trump signed a presidential memorandum. We have the quote here where he directs the United States to withdraw. And the key language, three key language points here, where he says to permanently withdraw the United States from TPP negotiations. Well, this is a presidential memorandum, and so the permanently withdraw language has as much force as the presidential language that it is overriding. More importantly, it references bilateral trade negotiations, and it references protecting American workers. And bilateral trade negotiations and protectionism, we think that those are very key hallmarks of this administration's trade agenda. Now, in what way is the TPP mostly alive? Well, there's still the other 11 countries, and those 11 countries have signaled a willingness to go forward without the United States. And even though the TPP is not the same agreement without the U.S., if you've got Japan, Canada, Mexico, Vietnam, and Australia, that's still a sizable trading bloc. The ministers of those countries have said that if they were to go it alone, they want to address their concerns about protectionism, which I think Jeff mentioned, and also you can see in the quote from the presidential memorandum we had. And they also suggested that the U.S. could be included at some point in the event of a change of heart in Washington, which really means a change of administration in Washington. Now, we also think that elements of the TPP might be incorporated into new or modernized agreements, and we're putting modernized in quotes because that brings us to Nafta. Now, just some quick background about Nafta. The language for Nafta, it was signed by President George H.W. Bush, and it was sent to Congress by President Clinton, so it had bilateral support. And not only that, because it passed the Congress, it passed the Senate, it was signed by Clinton into law, as opposed to the TTIP, which was never concluded, or the TTP, which they concluded the language, but they never ratified it. Nafta is the law. We've given the legal citation here for folks who might be interested. And the fact that NAFTA is the law, that really affects what the administration can do, how they can do it, and the effect of their actions. Now, candidate Trump on NAFTA was very clear. He called it the single worst trade deal ever approved in this country. Let's fast forward to May 18th of this year, where the United States Trade Representative sent a letter to Congress saying that the president intends to initiate negotiations with Canada and Mexico regarding modernization of NAFTA. That word modernization, that is the key word, because modernization means that they're not doing away with NAFTA. It means that they're going to update it. They're going to build on an existing framework in NAFTA. And basically, this is not controversial among the United States, Canada, or Mexico. All three countries are in favor of updating the agreement. Keep in mind, this is something, the language was negotiated in 1992 and passed in 1993. And so if you're looking at what's on the agenda for modernization, okay, some of the things that we think are almost certain to be in there: labor issues, environmental issues, intellectual property, and e-commerce. E-commerce really didn't even exist in 1993. It's hugely important today, so it obviously can only make this a better and stronger agreement. You might also see one-off issues. We have drawback in there for folks in the international trade field. You know, the drawback offers an opportunity for cost savings on certain types of exports that can be matched to certain imports. You do not get drawback on exports to Canada or Mexico, and we think that this might be changed under the Nafta modernization rules. Significantly, we do not see extensive modifications to the Nafta rules of origin. And for folks dealing in Nafta, they know that those Nafta rules of origin, that's really the heart of the agreement in many ways. That's really what confers duty-free status on a particular product, and there's a number of ways that that could happen. And we really don't see the administration opening up those rules of origin on each and every product. Certainly on individual products, no question, it could happen. So if you're looking at NAFTA modernization negotiations, which are, they've sent a letter, it's going to happen, where would you look if you wanted to get a sense of what they might be agreeing on? Well, here's a quote from the Huffington Post just a few weeks ago, and to read just part of it, where it says that the similarities between Lighthizer letter, which we have part of that here, and the ways the Obama administration discussed its negotiations over TPP appear to validate these critics' fears that Trump is simply enlarging NAFTA to make it more like TPP. Interesting, by the way, in looking at the USTR website today, TPP is still on the USTR website, the language is. Depending on how you access the TPP on that website, it's either there for, quote, reference purposes, or it's still interesting that in certain instances you can actually access the TPP webpage that was up there under the Obama administration. But the larger point is that if people are looking for specifics on where the negotiations might go, for environmental issues, for labor issues, for e-commerce issues, all of these issues were covered under the TPP, and it is likely that that is going to be a pretty good starting point, if not an ending point, for the NAFTA modernization negotiations. So now one other point on NAFTA, is it mostly dead or mostly alive? And we're pointing out that NAFTA is very, very much alive. And here we have for you the numbers on U.S. exports to Mexico and to Canada, both in 1993, the first year, and in 2016. And you can see that in 2016, total U.S. NAFTA trade in goods was over $1 trillion. $1 trillion, with exports, U.S. exports to Mexico and Canada at about $497 billion, about $500 billion. That's a lot of life in that agreement, and whatever they do, we really don't think that they're going to start fooling around with $500 billion approximately in trade. So obviously there's a whole host of other free trade agreements out there, predominantly the bilateral agreements. We've listed them here: Australia, Bahrain, Chile, Israel, Jordan. In terms of the multilateral agreements, really, you're talking about CAFTA, CAFTA-DR, and these are mostly alive right now. And the reason we're saying mostly alive is because we really haven't seen anybody talk about renegotiating these specific agreements. The most significant of these other FTAs is the Korean FTA, of course. And I think that I wouldn't be surprised if at some point in the Trump administration, if that got put on the board. But if you're trying to gaze into your crystal ball as to what's more likely or less likely, we'd say, first of all, look to non-trade factors. So if you were talking about, is the Korean Free Trade Agreement going to get renegotiated, look at other things that might be happening on the Korean Peninsula right now. Do they really want to start putting the free trade agreement on there if they're trying to get cooperation on all of these other things going on in the Korean Peninsula? Look at the ability to affect imports through other means, and that goes to what Jeff talked about in terms of trade remedies and what Michael Holton is going to talk about. And look at the ability to affect trade through other preference programs, the Generalized System of Preferences, and the African Growth and Opportunities Act. So to wrap it up, What do we see on the horizon? Definitely a strong preference for bilateral agreements, and we think the best bets are the UK, depending on how quickly Brexit occurs, and also Vietnam, we've heard. And as a final word for those wondering about whether Germany is going to open its market to Chevrolets, since that was a recent comment from the President, we would point out that there is no bilateral or multilateral trade agreement with Germany or with the EU for that matter, although there are a substantial number of General Motors autos being sold in the EU. So it's a balance. And with that, I'm going to turn it over to my colleague, Michael Holton. Thank you.
Thank you, Bob. I'm Michael Holton, I'm a senior counsel here at Husch Blackwell. I'm going to discuss maybe a little bit more practical element to the increased risk of the protectionism and potential trade remedies that are either in existence or the trade remedies that may come out of the other cases that have been recently filed. And this covers evasion and circumvention of duties. As in the past administration, set a priority on evasion and circumvention of duties, and that remains a trade priority issue for this administration and U.S. Customs and Border Protection. We believe that as the Section 232 cases on the steel and the aluminum come out, and as the scopes are defined, there's going to be greater risk for being caught up under evasion and circumvention investigations. Similarly, Section 201 cases will also increase those potential risks. Evasion is generally refers to entered merchandise covered by anti-dumping or countervailing duty order that results in any amount of the duty being improperly reduced or not being applied. And as Jeff indicated, that the cases for the Section 232 and Section 201 have generally been rare, and most trade remedies have been for anti-dumping and countervailing duty. But either way, those other cases, if duties are imposed, there's a risk that that parties will engage in evasion or be unknowingly caught up in such evasion allegations. Generally, what types or forms of evasion? First is transshipping merchandise through third countries for the purpose of changing the country of origin. Maybe falsely labeling, falsely valuing, misclassifying, or falsely reporting the manufacturer or exporter in order to avoid the duties. And really filling out any of your entry documents and not making false statements or not putting in the correct information can result in evasion. What we're finding now more, though, however, as this has become a priority issue, is that there's more mistakes of evasion. As this issue comes, we are finding that many importers are being investigated by CBP for evasion as a result of unintentional mistakes, for record keeping, and really general ignorance of the AD/CVD laws. What type of penalties might you face if you're found to be evading duties? When it comes to anti-dumping or countervailing duty, and any potentially of the new cases, the importer may be required to pay the highest duty rate. On the AD and CVD side, some of these can often exceed 100 or even 200% in duties. CBP could also begin to require the importer to use single transactional bonds or require other additional security. And in certain other cases where it may be determined to be more egregious, penalties pursuant to 19 U.S.C. 1592 for fraud, gross negligence, and negligence may also be imposed. Generally, in those cases, the most, along with having to pay the duty rate that you're required to pay, and the penalty could exceed as much as the domestic value of the merchandise. Finally, there are also potential for those truly bad actors of facing criminal penalties. I'm going to address some examples of current enforcement of evasion and circumvention of duties now for you. The first being certain circumvention taking place at the U.S. Department of Commerce. Covering cold-rolled steel from Vietnam, the U.S. steel manufacturers have alleged that certain cold-rolled steel from Vietnam made from Chinese hot-rolled steel is circumventing the Chinese order on hot-rolled steel because it's not being substantially transformed. This case is currently pending at the Department of Commerce. However, what's most interesting about this case and the next one is that this is an expansion of circumvention. That in prior cases, one would believe that given that these are considered different classes or kinds from cold-rolled steel to hot-rolled steel, that it would not generally result in a circumvention type investigation. But however, similar, then the U.S. Steel has also requested that the U.S. Department of Commerce consider corrosion-resistant steel from Vietnam made from Chinese cold-rolled steel. Again, the argument here is that they believe that it's not substantially transformed in Vietnam and therefore is circumventing the order on Chinese cold-rolled steel. Another case that's pending at the Department of Commerce has to deal with aluminum extrusions. This particular case alleges that the imports of the Series 5000 aluminum alloy is a later developed merchandise, even though the Series 5000 aluminum alloy was specifically excluded from the scope of the original investigation. So what we're finding in these cases is that parties are now being caught up in potential circumvention allegations where they were clearly defined or generally in the past would not be covered under such investigations. Recently as well, the government passed the new Enforce and Protect Act of 2015, or EPA as it's known, and this helped establish formal procedures and deadlines for allegations of evasions against U.S. importers. The EPA enforcement is really a shield and a sword for even importers or U.S. manufacturers by which they can request an investigation, and really any interested party is allowed to request an investigation. It's broadly defined. It includes foreign manufacturers or exporters, U.S. importer or manufacturer, unions or group workers and associations of any of the above covered merchandise. Really, this has become an effective tool for a lot of companies that are doing the right thing, that are participating with the government and willing to rat out potential bad actors that may be disrupting the marketplace. The EPA enforcement generally starts off with the issuance of a CF-29 or a request for additional information from CBP. The key point here that we've been informed of is that CBP does not inform the importer that they are under the EPA investigation. So when you receive a CF-28 request for information, it becomes important that you review it carefully and make sure that you see what potential solutions you may be able to take at that time. Another important element of the EPA enforcement that was passed is the potential for adverse facts available for non-responding requests for information. And this is important because what potentially the EPA Act allows CBP to request information not only from the importer, but to request information from the manufacturer or anybody in the supply chain. And if any of those parties fail to respond to the requested information, then the CBP could potentially make its determination based on adverse facts available. This is a new law. So far, there have been no final determinations in this case, and this goes back. It was just put together in last August in 2016. However, we do believe there's going to be a few determinations coming out here in the coming months. One example that we do know of is a case where steel wire garment hangers from Thailand, a U.S. manufacturer alleged that the steel wire garment hangers were being transshipped from China through Thailand, and CBP investigated the Thai manufacturer and determined that it did not have the capability to produce the number of hangers shipped. The third example that for current enforcement that's taking place is CBP self-review examples. And often in these cases, again, the party will be informed through a CF-28, a request for information, and a CF-29, and a notice of action in which the duties where the party will be asked to pay or apply the cash deposit duty rate. The first example that I have for you is applied the highest duty, is that CBP applied the highest duty rate because the manufacturer ID on the 7501 did not match the manufacturer AD case number used when they entered the goods. CBP applied the highest duty rate because there was no formal documentation included with an entry that the merchandise met the exclusions of the scope of the order. As many of you may be aware, if you're importing goods that may be covered by AD/CVD, there are many exclusions or many specific items that might be out from the order. For example, toy chests with furniture. And more CBP is requiring that there's some type of well-documented information that clearly indicates that that item is excluded from the order, or is an item that is excluded from the order, and not just because it's written on the invoice. Third example is we're finding this increasing as well in our practice, is that CBP is applying the highest duty rate because the importer inadvertently classified the product under an in-scope HTS US when the merchandise should have been classified under a non-scope HTS US, or could have potentially classified the merchandise as a non-subject part. Given the CBP implementation of the Centers of Excellence and the concerns over evasion as a priority issue, these types of cases are increasing substantially over the recent periods. And we have little doubt that if any of these other trade remedy cases proceed, the evasion will also continue to increase. Solutions for mitigating these risks. Know your merchandise. Obviously, people know what they're buying, but it's best to ensure that your merchandise is being classified properly. As the examples provided, we indicate that often there may be times where you can classify them under a different HTS number than one that would fall under a scope, and review your merchandise carefully. Know whether or not the merchandise is covered by an AD/CVD order from any country, as the investigations in the cold rolled steel and the corrosion resistant steel from Vietnam indicate that the raw materials coming in, those items are covered, and the potential for circumvention is there, and you need to try to do everything you can to mitigate those risks. Know your supply chain. Check your manufacturer. As the current EPA investigation shows on steel wire garment hangers, know whether or not your manufacturer has the capability to produce the quantity that you're ordering. Often, we find in a lot of cases where anti-dumping and countervailing duties are imposed on one country, suddenly another country, they're able to get the same deal, same quantity, within months after the case has been imposed. In those cases, it's often too good to be true. And finally, on that one, check the main raw materials. Know what is going into your product. Know whether those are covered by AD/CVD orders. Review your documentation. Keep a paper trail. Be sure your broker has the information, the proper information. As we indicated, the one case that a case that we've seen is that the difference between what was reported on the manufacturer ID and what was actually the actual manufacturer, has resulted in an investigation. Ensure your documents support with evidence your basis for excluding the merchandise from a scope order. If you believe the merchandise you are importing is not within the scope, make sure you're doing everything you possibly can to document that information when you're entering it. Finally, responses to CF-28s or notices for additional information are critical. Question why CBP is asking for the additional information. Review it, and if it generally is going to cover AD/CVD cases, we recommend that you have an AD/CVD lawyer review that information. Thank you, and I appreciate the time.
Okay, thank you very much. We're gonna now turn to at least, I guess we have at least one question. Bob's going to read the question, and then we'll respond to those.
Sure. We actually have a few questions, and I'm going to put the first two of them together and hand it over to Jeff, since that's really in his category. So the question is that on the 232 Steel investigation, based on the testimony of the CEO for AK Steel, do we have any sense as to whether any restraint will be imposed on not just steel, but also on imports containing the same type of steel? And is there any precedent for this broader remedy? Going along with that, another question, both great questions, by the way. Do we have any sense on what the remedies might look like? And I assume we're talking about questions on tariffs, tariff rate quotas, those sorts of things. So, Jeff, what's your sense?
Yeah, let me start with the question about the testimony of the CEO of AK Steel. I think he really touched on a very important point, and he did so, I think, pretty honestly, which is that we can protect the U.S. steel industry, and we can call it national security reasons, or we can call it whatever we want. But at the end of the day, what will happen is that it will render uncompetitive downstream companies in the United States, and sometimes those downstream companies employ far more people than the steel industry. I mean, look, having grown up in a steel-producing area myself, I can tell you it's like 25% as many people making steel as there used to be when I was growing up. So what's going to happen is the downstream people are the ones that are really going to feel the effects. So the question then becomes, what do you do? What do you do about that problem? And I got to think that the administration recognizes it as a problem. I mean, Wilbur Ross is familiar with the steel industry, certainly. So what do you do about it? Well, I think you have to have some degree of downstream protection, as was urged. Now, the real question becomes, how far downstream do you go? But I don't think they stop with just basic steel products. I don't think they stop with even pipe and tube and things. How far down do they go? I mean, do they go down to nails? Do they go down to further processed products that are made out of steel? I mean, by the way, the last thing I'm talking about is really what the guy from AK Steel was talking about was to go well beyond what people even think of as steel products and into things that are not really classified as steel at all, but as further processed products. The one reason I think they might not be able to do this is that Wilbur Ross says he's going to do this all in a month. I don't know how you do that. And I don't know how you do, I mean, I think it's difficult enough to do it simply on steel products, but once you start going downstream, it becomes much more difficult. So I guess I don't have a great answer to this. There was a question that was raised with regard to precedent. I can't think of an exact precedent because these national security cases have not been common. But there is precedent, at least in the dumping and countervailing duty context, of expanding the order beyond, the basic product and going down to things that are seen as a circumvention or an issue. So yeah, I think it's quite possible, and we'll see. The second question, Bob, again.
In terms of the types of remedies that you would be anticipating to come out of these investigations.
I think in a way that goes back to Bob's discussion of who the players are in this administration. In general, in a case like this, in past administrations, Democratic or Republican, the main player, the player that would be by far the most influential would be the U.S. Trade Representative. With some input from other agencies, for sure, but the USTR would be the most influential. I'm not completely sure. Well, I don't think that's the case here, quite frankly. I think that given who's running this case, it looks like Wilbur Ross is the most influential person. on this. The role that Peter Navarro will have, I don't know. But I think that the likely outcome is going to depend on who's making the decision or who's making the recommendation to the president. And the most obvious way to do this is to have increased tariffs across the board. But that runs into a whole lot of problems with NAFTA, with your obligations under NAFTA, with other foreign policy issues. Another way to do it is to have, I suppose, individual tariffs on different countries, but that's going to run into different problems with the WTO probably and other places. Another way to do it would be to have quotas, different quotas on different countries. I think probably the most likely, because it's just been done the most, is tariffs, because tariffs are pretty easily imposed. Quotas, as anybody who's ever worked under quotas knows, are incredibly difficult to enforce. There's a lot of transshipments. There's lots of stuff going on. Tariffs are a little easier, and so I would expect some kind of tariff levels, possibly at a fairly high level at the beginning and decreasing over time. I think the other question here, though, is for how long will these be in place? Whatever the remedy. Is it a year, 2 years, 5 years? Who knows? There isn't a whole lot of precedent for this. So those are the questions I think we're all grappling with.
Okay, so now we're just a few minutes after the hour. We're going to take one more quick question, and then Jeff is going to wrap it up. And this question is really for in Michael's shop, and the question is, someone pointed out that if they get a CF-28, a request for information, or a notice of proposed action, the 29, that comes from customs, but that anti-dumping and countervailing duties are administered by the International Trade Commission and the Department of Commerce. Could you briefly explain how that would work?
Yeah, basically the actual administration of payment and collection of duties is handled by customs, CBP. The determination of the scope and determination of whether or not there are actually any anti-dumping or countervailing duty, subsidies, or injury, those determinations are made by the U.S. Department of Commerce and made by the International Trade Commission. As many of you know, or may not know, is that generally when an investigation or a petition is filed by a U.S. manufacturer, the U.S. Department of Commerce will review the case and will establish the tariffs, anti-dumping duties, and establish the countervailing duties for the case. And then each year after that, it will go through a review to reset the cash deposits and apply the new duties as time goes on. The U.S. International Trade Commission during the investigation stage makes a determination on whether there's actually injury from the imports, whether the U.S. manufacturer is being harmed by the low-priced or subsidized imports of those goods in the United States. And that process is reviewed every 5 years. But from the day-to-day items, it's CBP that handles the actual collection of those duties, and often makes a lot of determinations on whether or not they believe the good is entering and is covered.
Yeah, and just a couple points on that as well to follow up with what Michael's saying, which I agree with. The other thing to keep in mind here is that CBP will consult with Commerce particularly on scope issues. To the extent that it's not clear to them what the scope is or whether something's in or out of a particular order, they'll consult, and they do that all the time. They're not going to make the call themselves. That is something that's going to be done and has been done for years. The other thing, though, is that CBP has been tasked with this by the new law. So they're clearly the agency that does it. There's a little bit of overlap or strangeness of the process, but that is how it's going to work going forward. So let me wrap up because we are a little bit over time, I think. couple things. First of all, I'd really like to thank everybody for joining us in the program today. We hope the information was helpful to you and to your organization. If you've not already done so, please click on the survey icon at the bottom of the screen to complete our short survey. That'd be helpful to us because this sort of feedback really helps us in providing quality for future programs. As a reminder, the program's been approved for Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, Tennessee, Texas, and Wisconsin for continuing legal education. A recording of the webcast will be available tomorrow for watching and sharing, and once available, a link to the recording will be emailed to you along with just a certificate of attendance. Again, this concludes our webinar, and thank you to all of you for attending. If you have any further questions, feel free to email any of us. Thanks a lot.